Appeals, Division 1 is now in session.
Thank you. Please be seated. We are here today for oral argument in the case of BAPCO LLC. I assume it's not it's set out BAPCO as opposed to BAPCO. Okay. BAPCO LLC versus Fidelity National Title Insurance Company, Court of Appeals number 1 CA-CV180345. We have reviewed your briefs. We have conferenced the case this morning. We're relatively familiar with the facts and arguments, so please keep that in mind when you present your argument today. Each side, you're allocated 20 minutes. Appellant, if you want to reserve some time, you're free to do so, but you have to keep track of the time yourself. We record these things and post them to YouTube, so when you approach the bench or when you approach the podium and start, please make sure you identify yourself and the party whom you represent, so that people watching online can identify everyone. And with that, we will begin.
Good morning, if you may please the court. I'm Dan Cloberdance on behalf of the appellant, BAPCO, who's also the plaintiff in this action, and BAPCO is the party making the claim under the subject title insurance policy. The central issue of this case, I realize there's a lot of side issues, but the central issue really comes down to this, is whether or not a title insurer has a right to retroactively amend or revise an issued title policy to a lender to correct an alleged mistake by the title insurer after that title policy has been assigned to a successor lender who did not have actual knowledge of that alleged mistake. In this case, the liens that were of record on the property.
So, and I'll interrupt and then let you get back on, but if this was an action between Diversified and Fidelity, you would agree that the court could correct any error?
Every day of the year.
Okay.
Absolutely.
How does assigning it somehow insulate the policy from thereafter being corrected, and why would Fidelity be disadvantaged because Diversified quickly sold off the policy? I know that's not the facts in here, but Diversified wakes up and looks and goes, "Oh, they made a mistake. Let's sell this off real quick and make a windfall." Why would that be the rule?
Well, that would be a cause of action itself if someone knew a mistake and sold a property with it. There's fraud there, but
that would be between you and Diversified, not between.
But let's take a look at the purpose behind a lender's policy and the purpose behind the language I'm going to talk about in a few seconds. That is really what the entire case hinges on. And there's a secondary market for loans. We're talking about lenders' insurance policies, very different than owners' insurance policies, where you go buy a home and you get a policy, and you sell your house, somebody else has to get a new policy. Loan policies go with the loan. That's the way the secondary market works. That's what this title policy says. It's an alternate lender's policy, and it automatically transfers. The title insurance issued automatically transfers to a lender who's a successor lender who acquires that loan. Nothing else needs to be done. And we look to the language of the policy, and this is language that the insurance company industry has put in their forms to protect the secondary market. So when you go buy a loan, you know you're going to get whatever insurance policy was issued, and you know you're going to have a right to enforce it as long as you didn't have actual knowledge of some infirmity.
But you don't have greater rights than your S&R, do you?
You do in this case, Your Honor.
Well,
because
obviously you must. If
you have,
win, but,
yeah.
But that seems like a real stretch to say that rights expand. Otherwise, that would be a great form of protection, right? Just sell off your portfolio and it's suddenly worth more than it used to be.
Well, I don't know if you could do that as a practical matter, and certainly selling loans is not a way to make money on the loans existing because they're always discounted.
You could make arguments about the financial crisis that might go against the point you just made, right?
Well, but there's another side to look at, and that is the secondary market is the reason the secondary market even exists is because we have alt-lender policies that are issued, and when someone goes, whether you're Goldman Sachs, you buy 1,000 loans in a package, or you buy 10 loans, or you buy one loan, or a series of loans, you know you're going to get the title insurance that goes with that, and then you know that you're going to be able to enforce the policy, even if there was something strange going on between the title insurer and the original lender, or the original lender and the the borrower.
Is that really right, though? Is this a case about a defect in title?
It's a case about, whether you want to call it a defect, it's a case where the policy is issued. There's no dispute here. Fidelity will agree to this, that if the court forces the policy as written, the title claim by BAPCO is covered. That's not disputed. The property insures this loan in first position. That's what the title policy says.
But if the court enforces the policy as anyone could have reasonably interpreted or relied on it, given due diligence, your client would not be successful here.
I'm not sure if you imposed a due diligence requirement, but that's...
Well, your client, I mean, this is a case in which your client essentially ignored parts of the file, right?
Well, he didn't have an opportunity. He didn't have an opportunity, or didn't review. He didn't go check the constructive notice. What would normally be constructive notice? Look, do a title search. Look at the liens of record. No, he did not do that in this case.
Okay. And so the defect in the transaction here is that your client, I think, would have to say, I reasonably relied on the notion that I was in first position when I bought this loan.
Your Honor, let's talk about that, because reliance is not a requirement for a lender to enforce a title insurance policy.
I know, but I'm just trying to peel back and get to the nub of the actual case. The defect of which your client complains is not that title was bad. The defect is that your client bought a third position loan and wants to be in first position.
No, Your Honor, my client bought a loan not knowing what position that loan was in.
So what difference does the policy make then? If your client is willing to buy loans without any regard to whether they're in first or third position, can you really expect to be insured against a defect that didn't matter to the transaction?
Absolutely, Your Honor. That's the way the lender's policy works. Whether you call it luck or a gamble, or whatever you want to call it, a client buys this gold chest, not knowing what's in it, these portfolio, these assets gold from the court chest. Receivership. Well, whatever.
Buying
maybe an old chest, old crumb.
Might be something other than a chest of gold.
It may be a chest of he doesn't know what's in there. Yeah, scrap metal. He buys something not knowing what's there. He's paid $20,000. It's a low price, granted. He's hoping to make a profit. He's hoping there's something in there that's good, or a number, maybe one or two or three, or how many items. He's got something where he's going to make a profit. That's why he's taking a gamble, and he purchased this loan, gets an assignment from the receiver for the court receivership, becomes the successor lender in the policy, gets a copy of the title policy, and the policy insures him in first position. And now we attempt to enforce that title policy. The title policy says that the company that the successor and ownership of the loan is subject to the rights and defenses as to any other successor the company would have had against any predecessor insured, such as the original insured, unless the successor acquired the indebtedness as a purchaser for value without knowledge of the asserted defect, lien, encumbrance, adverse claim, or other matter insured against by this policy as affecting title to the estate or interest in the land. So the policy itself, it says that the title company reserves its rights against the successor lender unless that successor lender doesn't have knowledge of something. Then the next paragraph defines knowledge. Knowledge or known means actual knowledge, not constructive knowledge or notice which may be imputed to an insured by reason of the public records as defined in this policy, or any other records which impart constructive notice of matters affecting the land. The lender's title policy in the definition section says, successor lender, you have a right to enforce this policy, and we reserve our defenses against the original lender unless you don't have actual knowledge of those. Further definition, we can't impute constructive notice of the records against the successor lender.
Is this a defense, or is this a question as to the scope of the policy?
Well, I think it's both, Your Honor. I think it's definitely a definition as to definition. The definitions define the scope of the policy, and it's a defense.
Let's assume
raised by Fidelity.
Let's assume there was only one loan. We don't have any concern about what position this loan is in. What did the policy insure against? It didn't insure against default, right?
No, it doesn't insure a default. What it insures against is any liens of record that are not accepted as exceptions in the title policy. So normally you would have a situation where if you were in second position, there would be a first lien noted in the policy, and that deed of trust in first position is
The deed
accepted
itself
from coverage.
noted subordinate liens, right? Or noted that it was subordinate.
The deed of trust has some ambiguous language that says this is subordinate to a lien apostrophe S of record. And as I explained in my reply brief, Your Honor, if we go into the hypothetical benefit, hindsight with benefit,
But
that lien of record isn't at issue in this
let's
case.
say it was. Well, why isn't it an issue? Because you say actual knowledge.
It says the first lien of record, the deed of trust. The first lien of record at the time this loan was made, the original loan was made, was an IndyMac loan that has since been satisfied or released. So if you go into that hypothetical analysis of going back to see what that first lien of record is that's mentioned in the deed of trust, that lien's been satisfied. That deed of trust does not mention the two liens that are subject of the title claim here. And Your Honor, the reliance issue, there's no case law anywhere, not in Arizona, anywhere I could find anywhere in the nation that says that a title insurer has to rely on a title policy in order to have coverage. It doesn't say that. I cited a Washington appellate case, Tumwater, which specifically says that an insurer could not reform its title insurance policy on the grounds of mutual stake, even though there's no reliance on the part of the insured. And again, we got to separate the normal contract law and deeds and title and just look at the title insurance policy here. It's a unique, lenders' title policies are very unique. And they're very unique in the way that the title industry has given protections to the secondary market and assignees of a loan. And perhaps to some extent, ignorance is bliss, because if you don't know of an error in that title policy, you're going to be able to enforce it. You have coverage. If BAPCO knew there was a mistake made, the title policy, by the language of the title policy, they do not prevail at all in this case. But the record is clear, and there was no evidence whatsoever presented that BAPCO knew about these title defects, and the title policy itself specifically says that you can't impute constructive notice.
So this is sort of the ultimate gotcha, right? It has nothing to do with the economic substance of the transaction or the reasonable expectations of the parties. It's just, I got you on a clerical error. I'm a latecomer to the transaction, but now give me $250,000.
Well, you're right to some extent, Your Honor. It is a gotcha, but let's look at Fidelity in this case. We sent out a title claim, advised the lender of, look, there's two liens of record. You insured clear title here. You issued a policy 10 years ago. We were making a claim. What does Fidelity do? They do their own gotcha. You know what? We think there might have been a mistake made. So we got you. We're going to revise the title policy by virtue of an Omaha lawyer in-house counsel sends you a letter saying, we hereby revise the title policy. You don't have coverage now because we just revised it. Gotcha. So if you want to talk about fairness, let's look at the facts of this whole case. Okay. And what Fidelity did in this case, where we asked them, work with us, help us out with these liens. They said, no, we're changing the policy. You're done. You got nothing. So that's why the lawsuit was filed, Your Honor.
Well, okay. So let's talk about what your client thought it was buying. What did your client think it was buying?
He didn't know. He thought he was buying a loan. He thought he was buying a loan that had title insurance, but he didn't. Well, he didn't know. He didn't know. He did buy the loan. He received an assignment, right, among other things.
He bought the loan, but he didn't really know the quality of the loan he was buying. He was just hoping to get lucky.
Yes, Your Honor.
Okay.
Yes, and we've conceded that throughout this case. To the credit of my client, he didn't lie and say he relied on the policy. He's an upstanding man, the principal. He said, I didn't know. But I do know when I got the policy, it ensured this is a first position lien, and I attempted to enforce it. Then they changed the policy on me, unilaterally changed the policy on me.
Did your client know he was buying a third position?
No, he didn't know what he was buying. There was nothing to indicate this was a third position loan. Despite what Fidelity said in their briefs, let's break that down. He did not know this was a third position loan.
I suspect we'll hear a perspective on that shortly.
When I'd like the record to be cited very carefully on that, because he did not know this was third position. There's nothing in the deed of trust in itself that says it's a third position either. You'd have to go into the escrow files and really make some speculation there as far as what happened.
I know this is really buying a mystery box. He didn't get. I mean, it just could have been a 10th position loan. He would have paid the same amount for it.
It's like Storage
Absolutely.
Wars, right?
What's what? Excuse me?
Storage Wars.
Yes, it's like storage. It's a lot like Storage Wars. That's a very good analogy, actually. Yes, he could have. And just with respect to one last point, I'd like to reserve my time for rebuttal. With respect to the whole secondary market thing, the fact that BAPCO paid a low price for the portfolio of assets, it should be treated the same as any other asset who paid value. And I don't think value is an issue here. We got action acquisitions case. It should be treated as anybody else who paid value for the property, whether he paid $200,000 or $2 million for this property. As long as he pays value and he's an assignee without notice, he should be treated the same as if Goldman Sachs bought this portfolio. And I'd like to reserve 5 minutes for rebuttal, if I may. Thank you. Thank you.
Thank you, Your Honors. My name is Jamie Thompson. I'm counsel for Fidelity National Title Insurance Agency, the title insurant and appellee in this matter. I think the court has noted on a critical issue here is that BAPCO had no idea what it was purchasing, or really had no reasonable belief that it was purchasing anything of value. What BAPCO did purchase was a deed of trust, which states in bold letters on the very first page that this instrument is subordinate to prior liens with an S of record. Any reasonable person could have looked at the record and seen exactly what those liens were.
But they also bought a title policy that said,
Right.
yeah.
Yeah, I mean, the insurer could have been reasonable and looked at the record too.
The insurer did look at the record and did disclose these liens to the original lender. The initial commitment, which is submitted with the brief and which was submitted to the trial court, shows that the two prior liens of record were disclosed on the title commitment.
Sure, but then the insurer issued a policy that insured more than it wishes it insured.
Well, the insurer issued a policy with a clerical error, but the agreement, the meeting of the minds between Fidelity and between the original insured, were that this lien was going to be recorded and insured in third position. That was the agreement. That was the deal struck. The written policy does fail to reflect that. I will concede that point. But the actual agreement to insure was based on the commitment, was based on the third position, and based on the letter from the insured acknowledging I am being recorded and insured in third position.
So
Let me-
I'm sorry.
Sure.
If the promissory note and the deed of trust accidentally had an extra zero, saying this is a $2.5 million lien, right? What do you do about that?
Well,
When you have a BFP who buys a $2.5 million note and the original party say, oh no, our understanding was that it was just $250,000. Do you expect us to enforce the original understanding against a BFP?
well, if we're talking about for purposes of title insurance, I think the policy limit amount in the title policy would control. And if the title policy said $2.5 million and the note and the deed of trust said $2.5 million,
But then you come in and say, oh, that was a clerical error. Sorry, there was just an extra zero. We really only meant, actually, there are two extra zeros. We'd like to keep this to $25,000. Could we entertain such an argument?
well, Your Honor, I think it's a completely different situation, and we're looking at, what was the initial agreement, and then what was in the documents that were conveyed, and what was the knowledge of the successor party. And this really is a run-of-the-mill reformation case, Your Honor.
Is it though? Because you heard the question I asked right at the beginning of your opposing counsel, right? Which is, why would he have more rights than Diversified would?
Right. And I don't think...
And I'm sure you would say he shouldn't. If we could do this against Diversified, we could do this against... But then his response, which is kind of interesting to me, is because the policy says I've got more rights than Diversified does.
But that's not what the policy says.
Well, doesn't it? It says reserving all rights and defenses as to any successor that the company would have unless the successor acquired the indebtedness as a purchase for value without knowledge of the defect.
Okay. A number of points on that, Your Honor. That's in the definition of insured. First of all, that is defining who is an insured under the policy, and there's cases cited by BAPCO in their brief that tell us that language is solely meant to determine who can invoke the rights under the policy, who is an insured.
But it also says what rights they can invoke.
Well, it does have a limitation of liability on the ability to raise defenses against successor insureds. But what Fidelity is doing here is not raising a defense to coverage. Fidelity is saying we never insured against this. We insured a third position lien. There is no defect here.
It doesn't just say defenses to coverage. It says all rights and defenses. So your right to get a clerical error corrected is a right, isn't it?
Well, again, this idea of actual knowledge as defined in the policy says it only applies where used in the policy, and the provision of the policy that gives us the right to amend to correct an error is provision 14C, and it makes no reference to actual knowledge. If Fidelity had intended to limit its right to correct a mistake in a title insurance policy, it would have, unless the successor insured had actual knowledge of the mistake, it would have put that language in section 14C. Now, Arizona rules on contract interpretation and construction tell us if there's a word defined in the policy and they mean to use it in a particular section, they put it in that particular section. Section 14C doesn't say anything about knowledge. And that's the provision that says, hey, if there's a mistake, we can correct it. And that's what Fidelity did. Fidelity corrected a mistake. I would also like to point out the Holm case, Your Honors, which is a ruling from this court which says essentially interpreting a contract provision as precluding reformation is completely at odds with the law of contracts. They were dealing with an integration clause in the Holm case, and the party made the same argument here. Well, this clause means that they can't reform to correct a mistake. And what the Holm case said is, if that's the case, you would have somebody who could prove by clear and convincing evidence, which I think Fidelity has done, that there was a mistake, but then still they couldn't reform the contract. The goal of this court is to enforce the intent of the parties. Making a ruling that says, well, this language, which has nothing about reformation or correcting a mistake, actually means to take away your equitable right to correct a mistake, takes away the ability of this party or this court to enforce the intent of the parties. And that should be the fundamental goal of this court, is to figure out what was the intent of the parties and to enforce that intent.
It's kind of a little bit beyond our scope here, but what is the market for these things? How does the market for buying loans in the secondary distressed assets? Because it seems like this could be a very important aspect of this decision. How much do customers or people like BAPCO rely on? And I know reliance isn't really an issue here because they haven't asserted a reliance, but it seems like they should be able to buy distressed loans and not do a whole lot of due diligence, but look at the title policy that comes with it and say, all right, this is a good buy for me.
Sure. And I agree with you to some extent that under the secondary markets, there are some protections, and some of the language in the title policy is focused on that, but there's a couple of distinctions here that they try to gloss over. One, even under the holder in due course law, a purchaser only gets what they purchased. If you buy a third position deed of trust, you get a third position deed of trust. And you're charged with any knowledge, actual knowledge, of what's on the face of the instrument you purchase. Here, the face of the instrument BAPCO purchased says, I am not a first position lien. So even under holder in due course.
But it also purchased the rights under the policy.
Yes,
and those rights change which is counterintuitive to me, but they do seem to change expressly based on whether you're a BFP or the original insured.
Well, again, I don't think that's a correct interpretation of the policy, and I think that's contrary to the Holm case. But what the definition of insured says, and if you look at the rest of the policy, you'll see there's certain defenses, like an exclusion 3 or 3B, which specifically call in the knowledge of the insured claimant, i.e. the knowledge of the successor insured. And what those cases are saying, or what that clause is saying, in which all of the cases BAPCO cites to, is that if the original deal was to be insured in first position, but due to some shady deal by the original lender, you end up in second position, you're protected against that. But it doesn't say when the original deal was to be insured in second position and you're insured in second position, you're protected. There is no defect in that point. There is no insurance coverage because you got exactly what you purchased. You got exactly what you paid for. There is no defect. There is no insurance coverage. And even if you accept BAPCO's arguments about this policy language, which I really don't think are a reasonable interpretation because they go directly contrary to the intent of the parties, and when interpreting a contract, the number one goal, again, is to enforce the intent. If you look at this, sorry, I lost my train of thought.
The intent of the parties.
Language of the contract.
Yes, the language of the contract and the intent of the parties.
Which are two different things in this case.
Well, again, there's no reason to ignore the law on reformation in Arizona. The law on reformation is clear that notice is the driving factor, and you have to be prejudiced in order to not be a bona fide. You have to be prejudiced in order to deny reformation. Here, BAPCO cannot prove any prejudice whatsoever.
I'm not concerned with the contracting around reformation. Reformation is a judicial remedy, not a unilateral mistake correction under the policy by the insurer. But, so that doesn't trouble me. But what does trouble me is that you have a document that specifically disclaims defenses when there's a BFP, and you have a document, the text of which does not reflect the intent of the parties.
Sure, but BAPCO here is not a BFP, again, because the instrument it purchased says right on its face that it is not a first position instrument. You cannot, he didn't
Can't
get...
be a BFP of a third position instrument?
Well, he's a bona fide purchaser of a third position instrument, but if he's the owner and holder of a third position instrument, he has no loss under the policy because he has a third position instrument. And that's the other key issue here.
How are you saying he had noticed he was a third position instrument?
Well, even under holder and due course principles, which is what BAPCO is sort of relying on, you are charged with knowledge that are in the face of the instrument that you purchased. The face of the instrument that he purchased says
lien with a
lien
parenthesis.
apostrophe S of record. So he knows he's not in first. I think at that point you have a duty to go and see what you are in.
You were in first position. Couldn't you have a deed that read that way? Just sort of a general disclaimer. This is subject to all liens of record, and the parties' side understanding is that there are no liens of record.
Well, I don't think this was a general disclaimer. It's in bold letters typed into the deed of trust at the first page that says, it just doesn't say it might be, it says this lien is subordinate to prior liens of record.
Certainly on notice of at least one lien.
Certainly on notice of at least one lien. But the other issue is that BAPCO has to prove an actual monetary loss under the policy. Now, there's no question that what Diversified had and what the receiver had was a third position deed of trust. That's what BAPCO purchased. He didn't purchase the policy. He purchased a third position deed of trust. Now, if BAPCO is going to have a loss under the policy, he needs to prove...
Let me stop you there. You just want to make sure I'm tracking you. Why do you say he didn't purchase the policy? It seems like that's a...
The policy is incidental to the deed of trust, but what he
It's
purchased...
a basket of goods. I mean, going back to the storage locker analogy, he bought what was in this basket, and...
Right, but what he
even if
bought
you later
is a
open that
deed of
box,
trust.
it's there.
Right. I mean, what he purchased and what's in the purchase order is a deed of trust. The policy is incidental to that deed of trust. I agree with you there. But what he purchased is the deed of trust. So if I buy a third position deed of trust...
Well, he purchased an insured deed of trust.
Yes. But he purchased a deed of trust that was...
It's like if you purchase a dog and the dog happens to come with a life insurance policy, then you also purchase the policy.
Sure, but under that analogy, if the dog dies, you have a loss because your dog is dead and you can recover under the policy. Here, BAPCO purchased a third position deed of trust. As we stand here today, BAPCO has a third position deed of trust. So how can BAPCO show any actual monetary loss under those facts?
So if you purchased a dog with an insurance policy that says this dog is insured as 100% purebred beagle, right? And it's not. It's half beagle. And then the insurer comes in and says, "Oh, we meant half beagle."
Okay. Well,
isn't that analogous to this case?
Well, again, I think you need to look at the facts and show what the initial agreement was between the original two parties. And again, Your Honor, I think it's completely at odds with contract law to say that you can contract away your right to correct a mistake. And I don't think any of the case law supports the finding that the definition of assured precludes reformation. All of those cases involve when there is a set of facts that everybody agreed to, and that is the policy is correct, but then they're asserting this defense.
Real estate transactions, we contract away our ability to correct mistakes all the time because once the closing occurs, the contract is superseded, right? right? So any mistakes that may predate closing are beyond reach after closing. Is that not true?
Well, Your Honor, I would go back to say, in an action for reformation, and the AID case tells us this, you reform the policy first, and then you figure out coverage. So if we've met the elements of reformation, under the AID case, we're entitled to reform the policy and to enforce the policy as reformed. And I don't think there's any question that in this case we've met the elements for reformation. We've proven that there was a mutual mistake. The escrow records are crystal clear on that issue. BAPCO didn't object to the admissibility of the records or object to their authenticity in the trial court. In the paragraph where we submitted those records, BAPCO said no objection. The records leave no question of what that deal was. So Fidelity has proven its right to reform the policy. And again, I don't think there's anything in the policy that can reasonably be interpreted as taking away that equitable right. So Fidelity has proven that it has an equitable right to reform. And under the AID case and Riley, Your Honors, you reform first and then you enforce and figure out coverage. So under that framework, I think it's clear that Fidelity had the right to reform the policy, and that under the reformed policy, there is no coverage. BAPCO purchased a third position deed of trust, and as we sit here today, it has a third position deed of trust. On the issue of the evidence, Your Honor, BAPCO made some arguments in his brief that there was not enough evidence of mutual mistake. Those arguments weren't raised below. There was never any argument that there wasn't a mistake, never any evidence offered to explain why the escrow records don't say exactly what they say. The escrow records are very clear.
Didn't BAPCO object to some of your evidence as lacking proper foundation?
So, Your Honor, the actual evidence was submitted as in response to paragraph 3 of our statement of facts. That's where the evidence was attached and was explained, and the custodian of records affidavit was included there. His answer to that paragraph was no objection. So he didn't object to the admissibility or authenticity of the documents. What he then does, the paragraphs that he does object to, are where we sort of glean facts from the documents, tell the court what the documents say. And he objects to foundation on those grounds. But if
He says that was a typo.
Well, Your Honor, he didn't say it was a typo. And he didn't argue in his brief anywhere below that.
I'm just pointing out the
He
argument.
can get up and
You're saying
reform his
documents
brief, though,
matter,
in a minute.
But then sometimes they don't.
Well, Your Honor, they didn't present any evidence whatsoever that could contradict the clear escrow records. They didn't present any argument that a mistake didn't happen. They didn't discuss it at all. Again, Fidelity's position here is that there is no defect and that there is no loss because BAPCO got exactly what it purchased. They're not entitled to greater rights than the assigner, and the title policy has never been interpreted in the way BAPCO asks this court
I would
to
assume
interpret it.
that. Let me go first.
Yeah, sure.
I would assume that this, like we talked about the markets before, that this has got to have happened previously. What's your best case for saying similar facts? You guys are allowed to go back and reform the policy.
Honestly, Your Honor, I don't think there is a single case out there which addresses reformation of a title insurance policy. I couldn't find one in Arizona. They don't point to a single one. Their cases all talk about like where a policy was as it was intended to be, and they try to assert a defense.
I'm saying beyond Arizona.
There is not. I couldn't find anything. They couldn't find anything. What I would argue is that the law on reformation applies to all contracts. AID tells us that, insurance contracts as well. And there is a case I cited out of court which just talks about reforming title policies in general. It's not about this specific language, but they say the law is generally if you didn't rely on the policy when purchasing the insured interest, then you can be reformed against because you're not prejudiced. There's no harm, no foul. You didn't know you were getting the insurance. So why shouldn't Fidelity get the bargain of the actual deal struck against somebody who had no idea what they were purchasing and frankly didn't care because they were paying pennies on the dollar for a bucket full of whatever it was. And so to hold Fidelity liable for $250,000 that it never agreed to insure in favor of someone who admits they did nothing, they didn't even read the instrument they purchased, had no idea what they were getting, and didn't rely on the policy.
People read their auto insurance policies.
Well, if I'm spending money on a deed of trust, I probably at least look at the first page to see what I'm getting. And I see that I'm not getting a first position lien. I don't go then try to get somebody to pay me $250,000 because I didn't get a first position lien, which I knew I wasn't entitled to. Again, Your Honors, I would urge that this is a run-of-the-mill reformation action. Title insurance policies are subject to reformation.
But before you sit down, you made an interesting statement. There was no loss. How is a loss defined by the policy?
A loss is defined by the policy as the difference between the interest you bargained for and the interest you received. Or,
well, do you have that language handy?
no, that is not the exact language. I do have the language. Actual monetary loss is what loss is referred to in the policy, and the provisions.
Well, I don't mean to trip you up, but if you have a copy of the full policy,
I do.
And there is a definition of loss.
There isn't a definition of loss in the definition section. In the introduction section, it says actual monetary loss, and there's a number of Arizona cases which say that's what's required to prove a loss under a title insurance policy is an actual monetary loss. And then there's other provisions for calculating a loss.
But it doesn't say in the policy that actual monetary loss is calculated against what your reasonable expectation was as opposed to what the face of the policy says.
No, it doesn't say anything like that.
So if the policy said $10 million policy, we would $10 million policy on a first position loan. What would we do with that?
Well, you determine whether there was a basis under Arizona law to reform.
I
and
didn't
if
get something worth $10 million. Is that an actual monetary loss?
Well, again, you'd have to look at the original agreement, and if you can reform the policy and prove the elements of reformation by law, then you determine coverage based on the reformed policy. So if you can do that, then you reform the policy and you determine the actual coverage. If you can't prove reformation, then you're stuck with the document, and I don't disagree with that. But
I hope the drafters of these policies sometimes watch these arguments or read the opinions that come out of them, because it seems so many of these insurance cases could be resolved by careful draftsmanship of the policy. Not your fault, of course. But,
Thank you,
thank you, Your
Thompson.
Honor.
yeah.
Thank you. I'll try to be quick. Working backwards, I've block quoted on page 41 of my opening brief the definition of loss in the insurance policy. It doesn't say actual loss, actually, although it probably means something similar. It says this insures against, as of the date of the policy, against loss or damage. Loss or damage are the words used. Not exceeding the amount of the insurance, the face amount, sustained or incurred by the reason of any defect or lien, encumbrance in title, unmarketability of title, or the priority of any lien or encumbrance over the lien of the insured mortgage.
So how has your client suffered a loss?
Because if you look at what the policy says, the policy insures the loan against what's liens that are not listed as exceptions. So when you've got $1 million lien that's been missed in the insurance policy, we go to the Swanson case from this Court of Appeals.
That still isn't a loss.
Well,
That's a difference. It's only a loss if the insurance policy itself constitutes a representation, and that's only relevant if reliance is an element, which you expressly said it's not.
Your Honor, I think reliance, if you look at the Swanson case, which talks about, from this court talks about an insured's loss. And reliance is not a factor there. Insurance loss is the difference between the fair market value of the property, if you don't have the encumbrances that were not listed, versus the fair market value of the property with those encumbrances.
So you're saying that the face of the policy is an important representation.
That's a cap of the dollar amount.
Okay. Well, if the face of the policy isn't a representation and reliance isn't required, where does the loss come from?
You need to look at the totality of the circumstances to determine if there's loss. In this case, we have a property, say it's worth $1 million. If there's no liens, that $250,000 loan is worth $250,000. Pretty much that's a given. If there's $1 million encumbrance and that $250,000 loan is behind $1 million, there's no equity in the property, it's virtually worthless. You still have a lien, but it's virtually worthless. And that's the Swanson definition, and it's also been applied. I've cited case law in my briefs.
But your client bought it not knowing or even caring what it was worth. So you encouraged us to look at the totality of the circumstances. How has your client suffered, other than the sort of false representation on the face of the policy, which doesn't matter because you say reliance isn't an issue? how has your client suffered a loss? Didn't your client get exactly what he paid for?
He didn't pay for anything necessarily that he was expecting to have, and I want to make that point very, very clearly, that what he did acquire was he got an assignment of a loan and a title insurance policy in which he's deemed the successor lender, which insures that loan in first position on the subject property. That's what he obtained as a matter of law, and as a matter of the definition of this insurance policy. He's the successor lender, and he has the rights to enforce that title insurance policy pursuant to the terms of that policy, which state that the title company cannot raise any defenses. They can't go back and change the policy unless he has actual knowledge of those defects.
I've never heard of a representation that was in any way legally meaningful without reliance coupled with it.
Well, this is not a representation case,
Okay.
Your Honor. This is at all. This is a
enough.
contract case.
Given the limited time, let's then move beyond representation case. Didn't the policy ensure that your client, or not your client, but your client's predecessor, got what they paid for?
No, it ensured. I think it's way too general a term to say that you got what you paid for. I don't know what the original lender paid for or was expecting. I don't have any ability.
The original lender undertook a third position lien.
Maybe. But beyond, let's talk about the evidence. No foundation, no affidavit from anybody explaining what happened on the underlying transactions. No foundation whatsoever. I objected to 10 different paragraphs.
Stuff, but not paragraph 3.
What's that?
You objected to a bunch of stuff, but not paragraph 3.
I'm not sure what she was referring to that I did object to. We conceded for purposes of our motion. Let's say there was a mistake made. Here's our legal analysis. We're still entitled to summary judgment because the policy states that only matters of actual knowledge can be imputed on a successor lender. So let's assume that's true for purposes of our motion. Then Fidelity comes forward with no evidence whatsoever, handwritten notes on a title commitment saying, here's what happened. Well, you have to have an affidavit or declaration from somebody saying what happened. We don't have that. We just got some cryptic
an
notes.
affidavit from the custodian of records?
Just
for the
saying
whole
this is the escrow file. That's all she says. She doesn't say a mistake was made. She doesn't say who wrote the notes on the title policy. She doesn't explain why the policy was issued. Sometimes insurance companies agree to insure over matters. They intentionally not list items they know about.
She authenticated the documents. Here are the authentic documents. No content. No opinion about what happened, but you didn't object to authenticity. And I don't hear you now saying they made these documents
Well,
up.
I objected to foundation.
Okay.
And
Did they make these documents up, or should we rely on them?
I don't know, Your Honor. I don't think they made the documents up.
Okay.
Let me say that. I think the escrow file was the escrow file. What we don't know is why the title policy was issued with those liens removed. Very often, title companies will intentionally insure over items for various reasons. That happens. We don't know. It's their burden of proof by clear and convincing evidence. That's what the law says. To get reformation, they have to prove that the two parties to the original contract intended to do something and they made a mutual mistake. It's their burden of proof. Again, I didn't want to concentrate on that issue because I don't think we even get to that issue because we have to enforce the policy. And there is a case I did cite on reformation, the Tumwater Washington Court of Appeals case, that specifically held the insurer could not reform its title insurance policy on the grounds of mutual mistake, even though there was no reliance on the part of the insured. 752 P2D at 935. It's the only case either was found, but clearly says reliance is not a factor.
What was the site again? 752
752 P second 930 at page 935, Washington Appellate, 1988.
Thank you.
Amount of time. Thank you.
Counsel, thank you very much for your presentations and your briefs today. We will take this matter under advisement and issue a written decision in due course. We are at recess.